that's okay with everybody. Thank you for being here today. I appreciate it. I don't know that this is not going to project out here, but we're recording there, so that if I look crazy carrying a microphone around, you know why. I may look crazy without a microphone too, but that's okay. I like to teach about legal issues from a historical perspective. And one of the things that I like to do is pay attention to how our predecessors did their job. And for the most part, they did very well. But we can always look back and learn lessons from that. And so one of the things I would share with you is in the tumultuous 60s and early 70s, our predecessors did some marvelous work. I'm still in touch with many of those guys. In fact, I just had a dedication ceremony for Art Sandine, if you've read any of his stuff. He's still at the University of Florida, and former vice president, was there about 26 years as vice president, and was at University of Iowa. I think it was Iowa State, I forget, before that. But anyway, he lived through the 60s and 70s and is an exemplar of how to do the work well. Others, the criticism I would have amongst lots of praise, so I want to be clear on that. I don't like to criticize people who aren't here to defend themselves, but among lots of praise for what they did in those times, I would offer a little bit of criticism and say to you, I would encourage you to avoid what some did, and that was they protected the status quo relative to what the law said, and they lost. Okay, remember, the law is always evolving. It is always evolving. Okay, so when students tell us today, I don't like what the First Amendment stands for, as an example. I don't like what that stands for. I don't agree with it. It's not that we should say, well, too bad. That's just how it is. I think what we should say is, and I'll steal from John F. Kennedy, who spoke at American University in June of 1963 at their graduation, a few months before he was assassinated. He said, in dealing with the Russians, as he got lots of advice, he had to remind everybody that he had to deal with the world as it is, not how we wished it to be, so that he could navigate that. And that's what I would tell you as colleagues. We have to understand what the law requires today, and deal with that today, and follow through on that, or we put ourselves at risk, we put our universities at risk. At the same time, we have to be respectful of the fact that students evolve the law. They have for 50 years. They've been very successful at that, and we have to note that and know that, okay? So be wise about that and understand that. Be strategic enough to understand that students can, will, and do evolve the law, but you also have to communicate to them, just because they're energized to evolve it, you have an obligation to enforce it as it exists today, okay? A little simple note I will say to you as I share some of this case law and some of the background and so forth. The law isn't evolved because of what administrators do. It evolves because students sue administrators, okay? It's not administrators suing their university. It's students suing their university and the administrators who make decisions around that, okay? That's how the law evolves. So keep that in mind. And I think we're at a point where the law, particularly around the First Amendment, is on the precipice of an evolution, okay? But it's always good to understand where we are today and know how that evolves us. Students have been very successful. As I said before, I'm going to combine two presentations today, and I'm going to be in TRF mode. Everybody know what TRF means? Talk real fast. So if you need to slow me down, just slow me down, but I'm going to try to get a lot of information in for you all. We've moved from in loco parentis, which doesn't mean crazy parent, it means in place of parent. We've moved from in loco parentis to a multidimensional legal relationship between the university and its students. Prior to 1961, students had no legal relationship with their university. They had no constitutional rights. They had some contractual stuff, but not much anywhere, and particularly they had no constitutional rights, okay? In loco parentis means in place of parent. We've talked about that. We're familiar with that. It was a legal construct that was the philosophical basis for how we interacted with students. It is not a construct anymore, okay? We see vestiges of it here and there, and we see uninformed colleagues who sometimes think that they operate in loco parentis, but we do not. And I want to share some of that with you. One of the first cases that helped create that legal construct is People ex rel Pratt v. Wheaton College. Pratt wanted to join a secret society, think Greeks, okay? And Wheaton College said no. Pratt's father sued and lost. The court reasoned among the rules Wheaton College, have deemed expedient to adopt is one forbidding students to become members of secret societies. We perceive nothing unreasonable in the rule itself. That's pretty pretty wild considering when you compare it to today. We could not say no. But then they could say no. Since all persons familiar with college life know the tendency of secret societies is to withdraw students from the control of faculty, okay? So there was this concept of control by faculty. Faculty would run all of university functions and so forth, and students would somehow withdraw from that control by joining a secret society. But whether the rule be judicious or not, it violates neither good morals nor law of the land and is clearly within the power of the college authorities to make it enforce. We, the court, have no more authority to interfere than we have to control the domestic discipline of a father in his family. In loco parentis, in place of parent. A person as a citizen has a legal right to marry or to walk the streets at midnight or to board at a public hotel, and yet it would be absurd to say that a college cannot forbid its students to do any of these things. Very different times. That was the construct of in loco parentis. GOTT v. BEREA College in 1913 drove the point home again. GOTT owned a local restaurant, filed suit against BEREA College for an injunction to stop enforcement of their rule. That the court determined that because BEREA College was acting in loco parentis, the college did have the authority to issue a rule forbidding the patronage by students of establishments not owned by the college. If we don't own it, you can't go there. Try that today, okay? Won't go very far. And the students at the college were obligated to conform their behavior to the rules, since a college or university may prescribe requirements for admission and rules for the conduct of its students. Two cases illustrate the lack of rights for students. And now we've moved from 1913 to 1924 and 28. Woods v. Simpson, Vivian Simpson was expelled from the University of Maryland for refusing to disclose whether she wrote a letter to a Washington newspaper that accused members of the faculty of making untoward propositions to female students. The Maryland Appeals Court upheld her expulsion, noting that discipline was a matter left to the faculty and requiring great delicacy, especially in dealing with girl students. Very different times, okay? Anthony v. Syracuse, Beatrice Anthony was expelled from Syracuse University without any hearing because it was believed that she was not a typical Syracuse girl. Now, I don't know whether she smoked cigars and played poker or what she did, but that was the outcome, okay? Very different times. That gives you an illustration of what existed through 1961, okay? And for some of us in this room, mainly the people up front facing this way, that's not that long ago, okay? For others out there, that seems a long time ago. This is a guy named St. John DIXON, okay? I got a chance to meet St. John DIXON in 2010. Took him out to dinner and his roommate out to dinner and spent some time talking about his experience at his Alabama University, not the University of Alabama, but his HBCU that he went to in Alabama, and how they organized a protest. And they sat at the whites-only counter, lunch counter, at the courthouse. And St. John DIXON ended up being the lead plaintiff in a very famous case, Dixon v. Alabama, decided in 1961. And because of his efforts, for the first time, college students had some constitutional rights. We're going to talk about that in just a minute. But St. John DIXON didn't know the outcome of the case, didn't know it was a famous case. He left college. He lost his opportunity to go to college when he got expelled. Governor Patterson called President Trent home and said, all these students involved in this, expel them, be gone. And President Trentholm went through all the records, and the ones that were close to graduation, he graduated. But St. John DIXON was a sophomore and not near graduation, and he lost his opportunity. He went to San Jose, California, worked with unions, just recently retired out there, okay? This is him in this picture right here. This is him, and that's in 2010. Very famous, and it was cool to talk with him, and there's so much history involved in this, and I won't be able to do it justice, but I'm going to share a little bit with you. That case is so cool. I was talking to him at supper, and I said, you guys were so organized, you know, when you did this. You had, they picked certain people in their group who could withstand what they thought would be the psychological pressures during that time. They knew they were going to get arrested. They picked the people who could withstand that to be the ones sitting at the lunch counter, but they also put up a communications. Remember, they didn't have cell phones back then, so they had to have a way to communicate. So they had people positioned that they could walk up to and talk. They'd walk a little bit and talk, and they could communicate back and forth that way to key people. And I said, how did you all figure out all this stuff? And he said, oh, we had some great support. We had a minister, we had a librarian, we had faculty, and so forth. And who was your minister? Martin Luther King was their minister, okay? If you didn't know that, that was pretty cool. They went to court, and by the same year I met St. John DIXON, I met his attorney, Mr. Gray. And Mr. Gray said, I'm a hell of a litigator, but I don't know a thing about appeals. And when we lost that case, we had to find an appellate lawyer. So we looked around and we found a bright young guy who was our appellate lawyer, and that's where they won on appeal in the old Fifth Circuit, now the 11th Circuit. They won on appeal. Their appellate attorney was a guy named Thurgood Marshall, okay? More history for you, okay? These things came together to create, for the very first time, constitutional rights for students. Established that students shall, prior to suspension or expulsion, be afforded due process rights to include, and what that boils down to in so many words is some kind of notice and some kind of hearing, okay, if you're going to comport with the DIXON standards. Now, since that time, we've had Supreme Court law, Goss v. Lopez, which subsumed the Dixon v. Alabama case, but where we sit today, that still is the controlling case in our circuit, if you will, for due process. For the very first time, students had due process rights. Didn't have them before. Now that kind of sea change in higher education created confusion for your predecessors. They didn't know what to do. What do we do in higher education when we're confused as an industry? We form an association, okay? So we formed one called NACUA, the National Association of College and University Attorneys. It was formed to help universities understand how to do due process. As it turns out, we were still horrible, okay? We didn't do it very well. Lawsuits abound. It's the 60s. All kinds of protests, all kinds of behavior. We're trying to respond. It's a new frontier. We don't know how to apply due process. We don't know what to do. And we end up in the Missouri courts. And the Missouri courts wrote a very important document. How many of you are familiar with the General Order on Judicial Standards? You need to find that document, okay? If you can't find it, look up on the University of Florida website, get my email me, and I'll send you the link and or a copy of it or both. But the General Order on Judicial Standards is general orders direct the courts on how they handle types of cases. And the court said, this is how you do due process in higher education. And so it's kind of a foundational document for what we do, all out of Dixon v. Alabama and our trying to understand as an industry how to give these constitutional rights for students the first time. John and Mary Beth Tinker, we moved forward in the 60s, okay? John and Mary Beth Tinker. Mary Beth Tinker's a 13-year-old girl, okay? She's wearing an armband here. You can see it's got the peace symbol on it. Vietnam War protest, and she's wearing the armband, and when she walks down the hallways, the students that are pro-war and anti-war kind of jaw at each other, and they get disruptive. And the principal says, if you wear that armband again, I'm going to expel you. And she says, well, I think I will. And he said, I think I will. So she wore it, he expelled her. She sued and lost. She appealed and lost, okay? 13-year-old girl, okay, going to court. But at the Supreme Court level, she won. It can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. Now, in the high school, grade school, elementary school, junior high school in those days, they didn't call them middle schools, they had, for the first time, constitutional rights for teachers and students contained in a Supreme Court decision. Now, it didn't apply to higher education yet, but that would be shortly taken care of, because after that case in 1969, we go to Catherine Healy. The picture on the left is Catherine in college, Central Connecticut State University, State Teachers College at the time, okay, which now is Central Connecticut State University. The picture on the right is Catherine Healy. In the last 6 or 7, 8 years, she still works at Central Connecticut State University in development, okay, that's what she does. But she wanted to form a chapter of the Students for Democratic Society, SDS. Most of us in this room, maybe I'm an exception, most of us in this room don't know about SDS, but at that time in our history on college campuses, they were burning ROTC buildings to the ground. They were flipping police cars and burning them. They were occupying administrative offices, particularly the president, all in protest of the Vietnam War, and they would find faculty members who they thought were doing research that supported the Vietnam War, and they would destroy their research, sometimes lifetimes of research. And President James said not only no, he said hell no. You're not forming a chapter of the SDS there. And she sued. And at the Supreme Court level, she won. Healy v. James, probably one of the most pervasive cases of, I get teased all the time by students when I teach law. They say, gee, I think if I just learned Healy v. James, I think I could pass law. It's about 80% of the law that you need to do it, be an administrator is in Healy v. James. I suggest you read it. But here's what happened in Healy v. James in 1972. Using Tinker as a foundation, that's important. That's what the court said. They brought Tinker in to higher education, just with that phrase. Using Tinker as a foundation, the Supreme Court noted the significance of the First Amendment at state college universities. Now, the argument from universities at that time was the First Amendment doesn't apply here. We operate in loco parentis. So that was their strong, strong argument. That was argument A. And the court said state college universities are not enclaves immune from the sweep of the First Amendment. Argument gone. First Amendment applies, okay? The precedents of this court leave no room for the view that First Amendment protection should apply with less force on college campuses than the community at large. That's a big-time ruling, okay? So Tinker is now brought in to the university setting, and Healy drives the point home that First Amendment rights, particularly speech and association, are intact, and they belong to students, and we have to afford those rights and support that, period, okay? That's a really important piece of information. The college classroom with the surrounding environs is peculiarly a marketplace of ideas. The courts still use that analogy. That means that all ideas come in, and we let students use their critical thinking skills that we're supposed to be teaching to navigate those ideas. The government can't protect people from ideas, all right? We're going to get back to that last phrase I just talked about. Yes, ma'am? Yeah, absolutely.
So in Tinker, they found that for teachers and students.
Yes.
Okay. So in Healy, is it administrators and students? Or
No.
just students?
No, this is just students, and we're going to get to administrators in just a minute, okay? It might make you sad, though. All right, but we'll get there. All right, good question. Great question. I love it. Okay, Chris Ernst. Anybody know who Chris Ernst is? Well, you're about to learn. This article at the bottom, I commend it to you. It's an ESPN article. It's online. Get that article. If you just type in Chris Ernst and tidal waves, T-I-T-L-E waves, you'll get it, okay? And the article describes why Chris Ernst is known as the Rosa Parks of Title IX, okay? She was on the women's rowing team at Yale. And every morning the women's rowing team would practice and the men's rowing team would practice, and they would get done. And they would go store their craft and then go to their separate locker rooms. The men's was a air-conditioned, heated locker room with nice lockers and all kinds of accoutrements and so forth to go with it. And the women's locker room was a trailer with no heat and no hot water. Okay? And so she did something remarkable. In this picture here, she assembled several women from the rowing team, and they met with the, assistant or associate athletic director for women's athletics, and they invited a reporter and a photographer. What you can't tell here is that she has no clothes on. They took their clothes off, and they had written on their sternum and on their back, what's wrong with these bodies, okay? And they met with the assistant athletic director, and for the first time, Yale was the first university, and the first time for Yale, they began looking at equity in sports, male and female sports. That's what caused Title IX to suddenly have teeth, was what Chris Ernst did, okay? I bring you all that so we understand the rich history of how students evolved the law. Notice there's no administrator there leading a protest, okay? There's no administrator that is suing somebody. Administrators get sued. Why am I telling you that? Some of our younger staff get confused about that, and they forget that the role of an administrator, particularly at a public institution, is very different than the role of a student. Students have some broad protections that staff do not, and we're going to talk about that, okay? All right, Title IX we know about. Prior to 2011, Title IX was about equity in sports, okay? Post-2011, it's about sexual harassment, sexual assault also. Okay. That leaves us with a relationship that has four dimensions: a constitutional dimension, a contractual dimension, a statutory dimension, and a tort dimension, if you will. And our job is to manage those four dimensions of that relationship, all right? There's a trigger for the Constitution, which we're going to talk about. That's just a little chart I use in class. You won't find this in any law book. I made this up. It just helps me remember, and I commend it to students to help them remember. If they want to remember another way, it's fine, but I do the 4 C's, and frankly, I stole it from Don Gehring, who was my law professor, okay? Constitution, contractual codes, I could say statutes, but they didn't have a C with it, okay? And then contact, I could say torts, but I needed something with a C. And then the trigger. For the Constitution, the trigger is state action. And we're going to talk about that in just a minute, because I'm going to spend the bulk of this time talking about the collision of core values, inclusion, diversity, and equity work, and the First Amendment, and talk about that, okay? Can I get the other presentation up? So I'm going to go through just some select slides here, and then I'm going to stop and let you ask me questions. And if you don't ask questions, then I have to inflict more slides on you, okay? So you can protect yourself by asking questions when we get there, all right? That's what I would suggest you do. Okay, very quickly, I'm going to just pick out a couple of these, and I have some handouts here that outlines all this stuff, okay? But contemporary students have a level of critical consciousness before stepping foot on campus. Many are politically active already, okay? Political activists in the student population are not new. The number is new, okay? And the experience is new, okay? Administrators will benefit from being able to operate and communicate a level of self-awareness that can communicate positionality in their different contexts. When I walk into a group of students with the big giant title of vice president, I tell students and staff all the time, I don't take myself seriously, but I take my work seriously. So it's okay to tease and cut up with me, and I try to get comfortable with everybody and have them be comfortable with me. But we have to understand that when we walk in a room, our title and what we bring to the table, you know, I'm a white male. And when I walk in, I have an impact that's different than somebody who's different than me. And I have to understand that. And I can demonstrate my level of understanding, awareness, and sensitivity by coming in and thinking in those terms and communicating in those terms, all right? Power dynamics, very interesting. Hierarchies are inherent in the work we do. Students, and I don't think this is new. I can remember way back in the dark ages when I was a student, students don't understand bureaucracies and hierarchies. They don't operate that way. Okay, so when we get irritated and we say, you know, I'm your assistant hall director, I'm your hall director, and you went all the way to vice president. You skipped the assistant director of residence life, the associate director of residence life, the director of residence life, the assistant VP, all the way to VP. They're gonna go, so? They don't know how that works. They don't care. They're not interested. They want to get the job done. They want to get their complaint heard, whatever. Now, if we're smart at my level, then we say, thank you for coming up. I appreciate it. I'm going to direct you back to these people. If you're not happy as you work through that, I'm happy to hear this at the end of the process if we do our job well, okay? Unless it's an emergency, and then we get on the phone and figure out a way to solve the emergency and make sure they understand that you solved it, not me, okay? Administrators responsible for understanding and impacting change on their campus. I'm going to build trust in advance. That's a really key one. If the first time you're seeing students is at the event, you're already behind the power curve, okay? They got to know who you are and how you operate and have touched you in some way, verbally or otherwise, before the event. Otherwise, when you come in, you're already suspect. That's a really important piece of information. Most of us know that. Don't quash offensive speech, okay? Get more speech in the equation. Teach the students why and how related to this, okay? We have a tendency as administrators to be tempted to quash speech. We hate speech. I'm going to give you an example here in just a minute. We hate some speech that comes out. That will get you in trouble, and you'll see why in just a minute. The trick to it is to get more speech in the equation. So back in 2008, when President Obama was running as a candidate, it was candidate Obama at the time, when I was at Texas A&M, the young conservatives put up a life-size poster of candidate Obama, put the planks of his platform out to the side, and they invited students to come and throw eggs at his poster. That upset another group of students. As it turns out, I had been doing a series of First Amendment workshops on campus for a number of months, which I'd always done at Texas A&M. And the students who were upset came to see me, a small group of them. They said, Dr. Parrott, I can't believe you're letting this go on over there. And we talked for a minute, and I said, you two or three folks, I think I saw you at a First Amendment workshop. Well, yeah, you did. I said, what did we talk about? Okay, yeah, we understand, we remember. I said, well, what was the goal of the workshop? To teach you how to get more speech in the equation. Okay, I said, well, go think about that, come back and see me. Well, they didn't come back and see me, but in about 45 minutes, they reserved a table near the Obama protest. They brought a couple of loaves of bread, some George Foreman grills, and they invited students to go over and get an egg and come over and make an egg sandwich, okay? And we had more students in line making egg sandwiches than we did in line throwing eggs at the Obama poster. Now, the young conservatives came to see me right away, and they said, they're stealing our eggs, Dr. Parrott, what are you going to do? I said, whoa, you're gifting the eggs. It's a gift, okay? The recipient can do with it what they wish, okay? It's entirely up to them once you gift the egg, so there's no violation there. A wonderful way to get more speech in the equation without quashing speech. That's the art we teach students. That's how you deal with speech you don't like. You don't quash it. You get more speech in the equation, all right? That's not a new concept. That was written about back in the early 1900s by the Supreme Court, by the way, okay? Sensitively support members of underrepresented groups in advance, during, and well after an event. Underrepresented groups, there'll be a residual effect that will go on for months. So you got to keep pulsing support out there after the event too. You can't just stop when the event's over. Teach the importance of creating a sense of belonging for all students and how hateful actions and words undermine this. There's a deep-seated need in human beings to belong, to connect, That's why we have sororities and fraternities as an example. That's why we have other kinds of student organizations. That's why living together on residence hall floors is attractive to students. They want to connect and belong. Okay? Stimulate that. Talk about that. Develop that. Make that robust. Okay? And then talk about with students the impact that has on a feeling of belonging when these events occur and how they can redouble their efforts and pulse out more belonging stuff. Work in the culture that you're in and develop that. Academic communities that are not diverse will be limited in their understanding of the world and will exclude valuable thoughts and experiences. That's why we diversify our campuses, so that our graduates have cultural competencies they wouldn't have otherwise, so they have other worldviews they wouldn't have, okay? That's valuable. When you have students who withdraw from that, we're letting them avoid part of their education. So part of what we're doing with championing diversity is enhancing their education. That's a foundational, fundamental thing that we do. I've talked about actions and words that diminish or reject someone's identity represent an acutely personal conflict. So you can't just say, that, and I would never recommend you say, oh, it's free speech, it's First Amendment, too bad, sorry you're hurt. It's more personal than that. Okay, you're really hitting somebody home and they need to hear your support. It may be that the First Amendment allows the speech to take place, but that's the third or fourth message. Okay, the first several messages should be about belonging, caring, and supporting. Okay, and maybe explaining about the First Amendment. But that explanation should be, remember when I talked with your group 2 months ago or 3 months ago or last year. Okay, remember when I brought this up at XYZ Assembly. Not the first time they're hearing from you about the First Amendment is at the event, all right? Students have a 50-year track record of success in evolving the law. There's some great examples. The law never is, it's always evolving. And I've talked about President Kennedy's remarks about dealing with the world as it is, not as we wish it to be, okay? There's some strategies there. I've got that on the handout. I'll give that to you. Some historical context. Now, you need to know this law. If you don't know this law and history, then you can be misguided inadvertently. So let me teach you a little bit. Any JDs in here? Got any JDs? Okay, all right. This is 42 U.S.C. 1983. That's the 42nd volume of the United States Code, Section 1983. Written in 1871. Wasn't written in 1983. It was written in 1871. This law was written to protect freed slaves. Why did freed slaves need to be protected in 1871? What happened in 1865? The end of the Civil War. What happened between 1865 and 1871? In jurisdictions across the United States, freed slaves tried to execute contracts, they tried to serve on juries, they tried to buy property, they tried to use government services, they tried to sue in court. And what did the court say? No. What was their basis? Why would the court say you can't do that even though they were free people? Why? What does our Constitution say about slaves? They're 3/5 of a person. If you don't know that, go read the Constitution. It's embedded in there. Slaves are considered 3/5 of a person. And the courts said, can't do that. Sorry, you don't have those services. So what did Congress do? They passed a law. Very important law if you're an administrator. Every person under color of any statute, ordinance, regulation, custom, or usage of any state or territory. That's anybody who operates under the authority of the state. Anybody here at a public institution? That's you. Okay? So if you operate under the authority of the state and you subject or cause to be subjected any citizen of the United States, and here's the magic language, or other person within the jurisdiction thereof. Uh-oh. That swept everybody in. Any person within the jurisdiction thereof, if you use the authority of the state and deprive them of rights, privileges, or immunities secured by the Constitution and laws, you individually shall be liable to the party injured in any action at law, suit, and equity, or other proceedings. Oh, wow. Okay? That should answer a couple of questions for you. Dr. Parrott, do international students have constitutional rights when they're at my school? Yep, they're within your jurisdiction. Dr. Parrott, do DACA students have constitutional rights enrolled at our school? Yep, they're within your jurisdiction. Here's another mystery for you. Why is Guantanamo Bay the debate that it is? Guantanamo Bay is a piece of land that belongs to Cuba that we lease for $1,433.73, I think it is, annually. All right? And we've been doing that since the 50s. I'm sorry? That's correct. They do not. But we write the check every year, all right? We lease the land, and it's a 100-year lease, all right? And people who are there, their constitutional rights don't attach. If we put them in our jails, their constitutional rights attach. Now, I'm not here to debate which one is right. I'm just telling you that's why it's done, okay? And it's based on this law. This is a law that attorneys use to sue government officials. How many of you are at public schools? You are a government official. You're the government, okay? So Section 1983 lawsuits are what you hear about. It doesn't prohibit anything. It is simply a conduit through which, if you meet those conditions, through which lawsuits are filed. Okay? You need to understand that. It implies we have to understand the rights, immunities, and privileges of students. And if we don't understand those, then we can find ourselves snagged up in this, and they always evolve. They always evolve, okay? Keep that in mind. Remember, though, here's something cool. You've got qualified immunity. Government officials performing discretionary functions generally are shielded from liability for civil damages insofar as their conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. You can't be sued. Isn't that cool? You cannot be. They can't take you to court. They can't sue you. You've got qualified immunity. You wear it like a cloak. Isn't that cool? It's great until you lose it. Okay. 3 ways to lose your immunity. The first way, if you violate clearly established law, the courts, the federal courts, and legal scholars tell us, legal scholars like Peter Lake, Gary Pavella, Don Gehring, and others, tell us that there is no more clearly established law than First Amendment law on a college campus, period. If you violate somebody's constitutional rights, you will lose your qualified immunity. That means you pay for your own defense and you pay damages. Recent case at Valdosta State in Georgia, okay, right up the road. President Zakari decided that he would suspend a student without due process because he didn't like what the student was saying, which is a violation of free speech rights. He lost both suits, the due process suit and the First Amendment suit. First thing was they stripped him of his immunity. Second thing was they fired him. Third thing was he paid about $700,000 and almost $800,000 over the course of 2 lawsuits in damages alone. I don't know what the attorney's fees were. When you lose a civil court case, you pay the other side's attorney's fees. Okay. The last litigation I was involved in at Texas A&M, the other side spent $538,000 in attorney's fees. They lost, but had they won, we would have paid $538,000. If you've got a spare $538 laying around, let me know. We'll have a hell of a party, okay? You won't have to waste it on a lawsuit, okay? I'll keep you out of the lawsuit. We can go have a party. It'll be great, all right? Keep that in mind. The other 2 things we're not going to talk about today for the sake of time, but there are 2 other ways you can lose your immunity. It's scope and role. We can talk about that another time. The Bill of Rights, and I want you to understand this, the Bill of Rights, what does it do? It limits, it's a list of limits on government power. It prohibits the government from doing certain things. Oh, wait, who here's the government? You are. It limits what you can do. It's not the people in Tallahassee and Washington, D.C. only. It limits what you can do. So when it says Congress shall make no law, the way the courts have interpreted that is if Congress can't make it, no lower level authority can make it either. Congress can make no laws that would impinge on free speech, impinge on the right to practice religion and so forth. We're going to talk about that in a second. But if Congress can't, you can't either. And the number of administrators that I deal with and talk with and work with all the time who think they can write a rule that somehow will impinge on free speech, it's crazy. Anybody here familiar with BEREA v. Shippensburg State University? Great case. Read the case. BAIR versus Shippensburg State University. There's actually 2 cases. The first case involved a hate speech rule that said you can't say mean, nasty, ugly things about other people, and it's terrible if you do. And the students sued, and they went to court, and Shippensburg said, we've never enforced that. We don't ever intend to enforce it. We just publish it. And the court said, the fact that you publish it has a chilling effect on speech, and you lose. Okay? Pay him a lot of money and pay his attorney's fees. 2 years later, because there's a second case, 2 years later, they lost again because they never took the rule down. Okay? An additional $400,000, I think, all right? Just promulgating the rule alone will cost you because it has a chilling effect on speech as the courts have interpreted it, okay? Keep that in mind. Keep in mind the Bill of Rights limits what we can do, particularly First, Fourth, and 14th Amendment. That's our purview, First, Fourth, and 14th Amendment, okay? All the 6 rights in the First Amendment, search and seizure stuff, and then due process and equal protection. That's our purview. That's the world we operate in, okay? That's the First Amendment. There are 6 freedoms in there, okay? Religion, speech, press, assembly, petition. That's the one we always forget. When I consult on college campuses, I've got a small little metal tape measure I take with me. And when I go on a campus that I haven't been on before, I measure sidewalks. Most sidewalks are in the range on most college campuses between 6 feet and 30 feet wide. That's important information to have when you're talking about the right to petition, because our colleagues out there deal with the following complaints and they respond sometimes inappropriately. Dr. Parrott, so-and-so is standing on the sidewalk and they've got a clipboard with a paper on it and a pen and they're accosting people, okay? And they're blocking the sidewalk. Most human beings are between 28 and 32 inches wide, okay? If you got a 6-foot wide sidewalk, a human being can't block a sidewalk, and the right to petition remains intact anyway. And it is a First Amendment right to petition for redress against grievances. What does it say? Petition the government for redress against grievances. Who's the government? We are, okay? So yes, they can have a petition with your name on it and talk about how mean you are. You're not, but they could talk about how mean you are, okay? And that's a First Amendment protected right. All those who are paid by the state are state actors. So if you work for a state institution, you are a state actor, period. The Constitution only applies when the state interacts with the individual. So there are no constitutional rights for students in their relationship with private institutions. They have other rights that are contractual, statutory, and under tort liability laws, but not under the Constitution. So here's some examples I give. Anybody here, if you're a sibling, you know a sibling, you can spell sibling, raise your hand, okay? Can you imagine a parent turning to a child and saying, go to your room and do a timeout, and the child saying, where are my due process rights? It doesn't exist. They don't exist in purely private relationships. Can you imagine 2 people in a relationship and one of them breaks up with the other? And the other one says, where are my equal protection rights? What happened? They don't exist. They only exist when the state interacts with the individual. They don't exist in purely private relationships. So they don't exist in the relationships that students have with private institutions, okay? That's just, okay, very quickly. I want to touch on a couple things. Here's one I want to touch on is a heckler's veto. We don't understand that. They're unlawful. We have an obligation to stop a heckler's veto. They work 2 ways. The first way is somebody who wants to stand up and keep another person from talking or another person from hearing. By the way, the First Amendment right to free speech protects the speaker and the hearer. That's important to know. It doesn't just protect the speaker, it protects the hearer. Let me explain why here real quick. I need to give you that information or that won't make sense. Okay, so you see those first five rights. The 6th right is the freedom to associate. Find the word associate in the First Amendment. You can't find it, okay? Why does it exist? Because the courts have said, in terms of religion, you can't practice religion by yourself. There's got to be 1 or more people there with you, okay? And abridging freedom of speech, there's speakers and there's hearers, okay? Speaking to yourself might be a form of free speech, but it's really not what people are interested in. They want to broadcast their views in some way, okay? Press, why would I print a newspaper for myself? Why would I go to that work? I want to hand it out to people. I want to publish it. I want to move it out so that my views are out there. Peaceably to assemble. 1 person might be able to assemble, but we're looking for more than 1 to assemble, okay? That's what an assembly is. And to petition. I can have the petition, but I get at least 1 other person to sign it. So the courts have found implied in there is the right to associate, okay? And that's really important. And that's what the Healy v. James case was about in large part, was that right to associate. The last piece of information I want to give you after heckler's veto, and that's where somebody, again, is trying to stop a speaker from speaking or a hearer from hearing. That's one form of it. The other form is where they come to your office and they say something like, if you let Parrott speak, I'm going to bring so much violence to your campus, it's going to tear your campus apart. And you go, okay, never mind, we won't let Parrott speak. That's also a heckler's veto. What you have to say under those circumstances is, we're going to ramp up our security. We're going to have to really pay attention to what's going on, but Parrott gets to speak, okay? That's 2 forms of heckler's veto, and they are unlawful. Brown v. Louisiana, Jones v. Board of Regents of Arizona, and very clear language in there about heckler's vetoes. First Amendment's been interpreted to prohibit the government, we're the government, from getting at the content of speech. I want to share 1 newspaper with you, and I'm going to open the floor for questions. But this newspaper, This newspaper was published. I've got a small copy of it. This is the small size. This is published by an individual, Miss Papish, at the University of Missouri, one of the University of Missouri campuses, not the University of Missouri. But she published this newspaper. It looks fairly innocuous. She handed it out on the one day of orientation they had to the parents and the students. There's some rough language in here, so bear with me. But this picture on the front that you can't see is a picture of a political cartoon. I don't know how cartoonish it is, but it's policemen raping the Statue of Liberty and Lady Justice. Okay? Then there was a group on campus. Here comes some language, so hang on. There was a group on campus who named themselves Motherfuckers Up Against the Wall. And they got charged with a crime. And they went to court and they were acquitted. And so she published a headline that says, Motherfuckers Acquitted. Okay? And then it gets worse from there. All right? And she handed that out. The president got incensed. He was irritated. He collected all the newspapers up and threw them away. That's illegal. Okay? And then he ran her through the disciplinary process. She was a graduate student. She was about 32 years old at the time. They ran her through the student conduct process. They expelled her. She sued and lost, appealed and lost, and won at the Supreme Court level, where the court said the government cannot, based on the conventions of decency, get at the content of speech. Write her a big check, put her back in school, and leave her alone. She likely took the proceeds from the lawsuit, transferred to Bowling Green State University, and lived up there, and she died in 2013. But that gives you a little bit of understanding. I'll bet if Motherfuckers Acquitted is protected speech, there's a lot of other speech that's protected that we wish wasn't, but it is, okay? That's a great example. I use this all the time. I'll pass this around. I use this all the time to educate some of my fellow administrators when they want student affairs to shut down speech. I like taking that piece of paper with me, and I've got a full-size copy of it, so I share that all the time. Okay, I've covered one last thing I want to share with you is there are 3 levels of protections on a college campus to get at your original question. At the top of the apex are faculty in class on topic, okay, or in their research. Now, faculty don't have absolute free speech rights because they can't use their verbal skills to sexually harass, as an example. But if they want to talk about something, if they want to teach a class on pedophilia, because we think it's cool that they study that so they can stop its antecedents and prevent it from happening, and they want to teach a class on that, we can't stop it, okay? That's an example of that. Next level down are students. Students have broad protections of free speech rights as they move across campus. They can wear T-shirts with bad language on them. When I first went to Western Michigan University, there was a student there. I was there about 2 weeks, and he had a shirt on that said FUCK on the front. And the dean of the college the honors college called me and said, hey, this guy's right outside my window here, man. You need to do something. What are you going to do? Nothing. And then I got a call from the secretary of the business dean, and she said, he's in our lobby. What are you going to do? Nothing. And then I got a call from the president's secretary. She said, he's right out front of the flagpole. What are you going to do? I said, well, it's the president. I'll be right there, okay? So I walked over, and he was standing there, and his friends scattered as quickly as they could. And I walked up, and he had a big shirt on with, I guess they were 10-inch letters, said FUCK. And I walked up, and I could see the president watching me out of the corner of my eye, and I said, you have not violated one rule of this university, and I want you to know that, okay? Now, the president this day thinks I really gave him hell, all right? And I said, do you really want that to be your reputation? He said, nah, I've had my fun. I'll go home and change my shirt. I said, okay. To this day, the president thinks I really did something. The kid changed his shirt. It's all good stuff. But protected speech. Protected speech. Remember that, okay? Third level. Grit your teeth. Hang on, okay? Very famous case, 2007, Ceballos v. Garcetti, or Garcetti v. Ceballos, depending on whether it's an appeal or not. Supreme Court case. Outcome of the case. Public employees commenting in a public way on policy matters do not enjoy the protection of the First Amendment. There is nothing in my job that isn't a policy matter. I don't know about you, okay? But you do not have constitutional rights as a staff member. They don't exist. No First Amendment rights, none, zip, zero, nada. Okay, be careful. I have staff members I had them at Texas A&M, I have them at the University of Florida say, I have a constitutional right to do this. Nope, you don't. You're crazy. Yeah, I am crazy, but you still don't have a First Amendment right, okay? It doesn't exist. It just does not exist. I don't want to see anybody get hurt or harmed. I was speaking at the APLU provost meeting and sharing this, and the provosts were just losing their mind because they didn't know that. By the way, that court case exempts faculty, so it doesn't apply to, it specifically says this does not apply to faculty because of their tenure and academic freedom protections. But it does apply to everybody else, okay? I'm going to stop there and open for the questions. It would be fair that both are true. They do not retain constitutional rights, and in many states, your employees at will, and you can go away because it's Tuesday. Yeah. So the bottom line is that you do not enjoy the protections of the First Amendment when you comment publicly on policy matters. Okay? And public is anything beyond you. Okay? If you want to sit at home drink a cup of coffee by yourself and comment, go for it. But beyond that, it becomes public. Nobody's going to come and get you because you and your buddies are sitting around drinking your favorite beverage and being angry because there's not a raise this year. That's not what the law is for. Technically they could, but that's not what the law is for. It comes out of a case where an assistant district attorney told his boss they had a bad search warrant. And the boss said, well, no, we don't. It's a great search warrant. He said, no, it's not. They went in court the next day to prosecute the case, and the first witness on the other side was the assistant district attorney. They kind of went downhill from there. Okay?
How does this apply to grad students who are also employed?
There's two categories of students: the grad students who are GAs, the grad students who are taking class and are GAs, and RAs. Okay, they're employees. Yeah. The other side is going to say when plaintiffs sue, it's not going to be up to it's going to be up to that student to prove they were not in an employment role. It just doesn't come automatically. Okay, the last thing you want is a jury of 9 or 12 people determining your status. I would be very wise in training folks and teaching them that. And that's not to say that students who are graduate students or students who are RAs don't have constitutional rights and they want to go be in protest and so forth and so on, but they've got to be wise. I've had students in residence halls who lead the protest as staff members. We part company, okay? Period. That's not their role. And they're incensed, their parents incensed, their lawyers incensed, and I've never been sued once I share the case law with them. When you're in, so let me make it easy. If you're a TA, you're a teaching grad assistant, you're in front of class and you're saying XYZ policy is stupid or XYZ political decision is stupid, I want you all to know that as part of what I'm teaching, you're on thin ice. You're on thin ice. I would make sure that I had some real clarity in what my role was when I was exercising my right to free speech. There's a great case up in Kansas City, I think, where an assistant football coach at a college wrote a letter in support of a particular council member election, put it on letterhead from their school and everything, got in all kinds of trouble, lost his job and so forth. So just a lot of folks don't believe it's true, but it is indeed true. Okay? Yes, sir. Mm-hmm.
Where it says that particularly in this case, black people do not have the same amount of rights.
Yes.
Or at least rights that white men are not allowed to, or
yes.
Respect.
Yes. Yes.
So having that, and that law is still, or that ruling is still on the books today. And so looking at that in terms of being able to articulate whenever things are done in terms of students, in terms of, when we're responding to civil liberties and civil rights issues, in terms of having that sentiment still on the books, and then be able to say, well, you still have these protections under our jurisdiction. I'm just trying to.
For education, Plessy was overturned with Brown.
Right, but still, like in terms of like that sentiment is still there.
Mm-hmm.
It's not necessarily the segregation, but the sentiment in terms of like you still don't have these. There's nothing that says that we have to respect actually.
I think that's a flawed idea, that somebody doesn't have to exercise equally or give those equal protections across all populations. That's why we have to be savvy at this stuff. We have to know this stuff. We have to lead and model. We have to know this well enough to be facile with it and communicate it. And if somebody came to me with that argument, I would say it's a false argument. That every student here, for a whole variety of reasons, enjoys all of their constitutional rights, all of their statutory protections. And that's part of what, at a public institution, we not only morally have an obligation, but we have a legal obligation. Now, the reason I don't want you to hang your hat on legalities, though, because the law sets the minimum. That's the floor. We can exceed that, okay? And that's what we should do in higher education in terms of that belonging, all right? And making sure that we communicate. The minimums are here, But at this campus, here's how we're going to support those students who are part of our community. And we can do that. Now, you can't violate somebody else's constitutional rights in doing so. I just talked to our colleagues at Berkeley. The chief of staff out there was at an AVP institute I was doing, and we talked about this. In Berkeley, one of the institutions that sees themselves as a First Amendment, stalwart, they went through and reviewed themselves, and their final take on it was, we were impinging on the free speech rights of conservative students, and we don't want to do that. So their watchword now to all their staff is content neutral. So she said, we may get T-shirts just say content neutral. We want to make sure we drive that point home, because while we're protecting the rights of all of our community, we can't quash the rights of part of that community. I think that gets at a piece of what you're talking about. Yes, ma'am.
So what happens if, let's say, students on campus create an organization or put up flyers or something? That could be somebody may perceive as a Title IX issue.
Uh-huh.
So naked women is something,
Do you,
a hostile environment for women.
have you read the Dear Colleague letter?
Yes.
Okay, go back to 2003 and read that Dear Colleague letter. And it says clearly in there that nothing the Office of Civil Rights, the Department of Education does will require you to violate the First Amendment. You got to read all of them. We've just read the one in 2011. Go back to 2003 and read that one. Still there, still very prominent. Okay, they were very clear in that. Yep. The other thing I would tell you is, if you were in my law class, I would say go back to Marbury v. Madison. That's one of the first Supreme Court cases, 1803, and they said very clearly as part of that decision that the Constitution is the supreme law of the land, and anything that doesn't conform with that or comport with that is in violation of the law. So if I were going to make a choice between a statutory right and a constitutional right, I would go with the constitutional side. The third piece I would tell you is there's a 4-part trigger for harassment. Okay, we never can get the fourth part. Okay, the fourth part is it deprives someone of the privileges of the federally funded program. We can get the severe, pervasive, objectively offensive, but that fourth part we don't get. And so it probably doesn't rise to the level of harassment because somebody's got a, whatever it may be. Okay, we're going to have a club and look at pictures of naked women or naked men or whatever it may be. Okay, and if you've got more questions, I've got lots of examples. I just don't want to over answer your question. We had some other questions. Yes, sir. Well, still unsettled. The Second Amendment's not incorporated. We just had a Eighth Amendment case at the Supreme Court where they incorporated the Eighth Amendment right. You don't know what incorporation is, and I'm not going to bore you to death, but in those constitutional rights, some of them are what's called incorporated. That means that they apply to all the states, and some of them are unincorporated, which means they may or may not apply. And the Second Amendment is not incorporated at this point. There's a big push by people who are pro-gun to get it incorporated, okay? And we just had, I forget the case, what it was about on the Eighth Amendment. I'm blocking on it, but it just came out last week. And it actually incorporated that part of the Eighth Amendment, so it applies to all the states. And I'll think of it here in a minute. Does that help a little bit? Okay, all right. Other questions? Yes? Well, unions have a right to free speech, okay? Union members have a right to free speech. We can disagree and have opposing views and have a right to exercise that free speech. We can't interfere with each other as we exercise that free speech. Read the Skokie Nazi Party versus Skokie, Illinois case. That's where the Nazi Party wanted to hold a march through Skokie, Illinois, which is primarily a Jewish community. And the Jewish community didn't want that to happen, and they sued, and at the Supreme Court level, the Supreme Court said, no, still a constitutional right. They get to march, okay? As abhorrent as views are, they still are protected under the current interpretation of the First Amendment. By the way, pre-1960, the First Amendment was interpreted differently than it is now. It's always evolving. That interpretation will evolve. But today, that's the interpretation. If you go pre-1960s, where you get the Chaplinsky case, which was the fighting words case that everybody keeps referring to, which has been it's been overturned, parts of it overturned. The only thing left of the Chaplinsky case, by the way, the Chaplinsky guy, you know what he was found guilty of? What was considered not protected speech? Let me get this straight. What he was arrested for saying, and they upheld the arrest. he called somebody a goddamn fascist. So pre-1961, that was not protected speech. Okay, now it would be protected speech. Our interpretation has evolved. That's the fighting words case, and I still see people to put fighting words in their rules, and in my opinion, you're misleading your students, because students think somehow if somebody says something that makes me mad enough to fight, that's protected. It's not. The only thing left of the Chaplinsky case and the Chaplinsky test is toe-to-toe threats. I've got to stand toe-to-toe with somebody and make a true threat. I'm going to stick this knife in you as a true threat. I don't think you belong on campus is not a true threat. Okay? So the only thing left of Chaplinsky is toe-to-toe threats. And there's a whole line of cases. Terminello is one of them, v. Chicago is one of them you can look at. I'm a little rusty on this stuff, so I'm not recalling all the cases, but there's a whole line of cases on that. Other questions that I can answer? Yes?
Can you give us some context, going back to something we talked about a few minutes ago regarding staff?
Uh-huh.
Our RA staff, our graduate staff are some of the most vocal student leaders on campus. So what are some things we can do, or what have you seen work best at your institutions or other institutions that help establish clear expectations and positive relationships associated with staff?
Well, everybody's wrestling with this. It's the thing that everybody wrestles with, okay? Because what do we know about students who are really pissed off or who really are activists or both? They don't want any impingement on their ability to do whatever it is they want to do. They live in the gray areas, and we're talking about a gray area, okay? And so I've had RAs that would say, tell me how many feet outside the residence hall I have to be before this doesn't apply. I don't know. Okay, I don't know. There's no rule that says 27 feet's bad, 26 feet's okay. It's not that simple. Okay, I'm just saying that when the lawsuit comes, okay, because somebody thinks you did something to violate their rights, and you're going to say, no, I was not an RA at that time, the other side's going to define that, not you, unless you're very, very careful. Okay? A hard thing for RAs to understand and GAs to understand is if you get paid for work, you're an employee. You're not a part-time employee. You're not also a student. You're an employee. Everything else is coincidental. Okay? And so you too can be sued for violating somebody's free speech rights. The thing I get oftentimes is I'm an RA. If I go do something, I'm just an RA. So I can go. The one I dealt with at Western Kentucky University many years ago was an RA pulled down all the Playboy centerfold pictures off the front door of a student, and he said, what do you want me to do with these? I said, put them back up. He was just incensed. He couldn't believe it. And I said, it's protected speech, and I get it. And he said, well, I think it's horrible. Maybe, but you're the government. No, I'm not the government. I'm an RA. No. You get paid by the state too, okay? You're an employee. It's hard to grasp, and you have to train them. And then every campus culture is different. University of Florida is much more activist than Texas A&M University, okay? And I have to adjust to that. Texas A&M University, not so many activists. University of Florida, many activists. I just educate staff, and here's what I tell staff. Tina sat in some of the meetings, got bored to death with it, but what I tell staff is, I'm not going to terminate you because you're leading a protest. I'm not going to do that. I might tell you that wasn't the brightest idea you ever had, okay? But I'm not going to terminate you. But a board member or legislator who calls the president and says make it happen, deal's off. Okay, I'm not going to initiate termination. But if they say you're gone, there's nothing I can do. Okay, that's it. So be wise to that. And they're kind of, I've had them come up and meet with me and say, I want to understand what you're saying. Okay, which one of those words do you not understand? Because I'll repeat all of them. Well, I think I've got they pulled out the Constitution and showed it to me and said, I'm very familiar with that. Doesn't protect you in your role as an employee. Two of them at University of Florida have discussed this with an attorney, and they came back and they said, it pisses me off that you're right, but we've got a good relationship, okay? They're pretty cool about it, Yes.
Just want to do point of clarification about not being sued. Like, we can be named, we have been named, but we have protection.
So a great question. First and foremost, don't do your job worried about lawsuits. I've been sued so many times. I just worry if they spell my name right or not. Okay, don't let that worry you too much. Keep yourself in a posture where suing you is not going to be successful. One of the first things they do in many states is they determine whether your behavior would cause you to lose your immunity. And they answer that question. Georgia does that. They answer that question first. Texas does it last. So you go through all the way through the process. Then in Texas, at the end, they go, you've lost your immunity, which means you pay the damages. In Georgia, they decide that up front. Find out how it works in your state. But yes, you can be named on a lawsuit. But lawsuits are cheap. A lawsuit costs about $135 and somebody with a law degree. And you know, I've got stacks of those. Most of them go nowhere. Okay, most of them you can talk your way through them, or they don't have a basis, or we win on summary judgment because we've made sound decisions, and then it goes away. But for somebody to successfully sue you and cause you to lose your immunity, they're going to have to show that you knowingly violated clearly established law. And that's why I talk about the First Amendment, because it is so clearly established, and many people don't understand that. And they don't know what that means. And so we get into all kinds. I was just at a meeting of vice presidents where one vice president suggested using the Wisconsin v. Mitchell case, which allows us to enhance a penalty based on whether somebody chose somebody in a protected class. So if I chose a woman or someone because of their race or their country of origin to perpetrate a crime against, the court said you can enhance the penalty. That's okay. We do that in our student conduct processes, but here's what you got to be careful of. You got to have a law, a rule that's lawful. So they were thinking about, well, we'll just write a rule that says you can't say mean, nasty, ugly things, and then we'll enhance the penalty. No. The first thing you got to have is a lawful rule to violate. Then you can move to that penalty phase. You can't have an unlawful rule. You will never get to the penalty phase. You'll be spending too much time in court. People who write rules that are constitutionally infirm have a name. You know what they're called? Defendants. Okay, don't do that. Don't do that. Write sound rules. Let general counsel look at them. Don't let the emotions of the day or the circumstances cause you to write a rule that won't work. Okay? Another little tip. Let students know well in advance through websites and publications and so forth what your university position is on the First Amendment. Students think we make this up on the fly. Okay, so we have, at University of Florida, we had Richard Spencer on campus. You all familiar with the white supremacist? He was on our campus. I've got some documents up here. If you want to see them, I'll share them with you. ACE uses the Florida response as a model. You're welcome to pass those around. That's on the ACE website. Keep in mind that the students at that time said, you know, why are we letting this guy on campus? You're crazy. You're an idiot. We can't believe it. One of the things that we realized is we didn't have our position firmly up on a website. So they thought we were making it up. Oh, you're just doing that because you guys want this to happen. You could stop it if you wanted to, okay? If you put a website up and they go back and they see it was put up in 2019, it's 2022, then you're not making it up. It's a position you've had for a while. So get those things up as soon as you can. Any other questions at all? You guys have been wonderful. Thank you for your time. I appreciate it. All right.